Unlike most other countries in the world, you cannot establish trademark rights in the United States simply by filing a trademark application. Establishing trademark rights in the US requires actual use of the trademark. But there's a lot of confusion and misinformation about what type of use entitles a brand owner to nationwide protection with a federal US trademark. Let's clear up the confusion and debunk the myths. Hey friends, welcome back to my YouTube channel. I'm Faith Minton, an attorney on a mission to simplify trademark law for entrepreneurs and business owners so that they can better understand their legal rights. Here you will find tons of content to help you understand trademark law better and learn how to navigate the crazy world of trademarks so that you can stay on the right side of the law. Now, with each of these videos about trademark fundamentals, I like to start by defining what a trademark is, just so that we're all on the same page and we all know what I'm talking about. A trademark is a type of legal protection for a business's brand identity. Most people recognize names, taglines, and logos as these really quick marketing messages that help people identify a brand. So that's why these three items are most commonly registered as trademarks. But there are also non-traditional trademarks for things like building designs and colors and sounds and scents and hashtags and domain names and other things that brands invest tons of time and money in marketing so that those things can identify the brands too. But regardless of what you choose to apply for, whether the traditional trademark or the non-traditional trademark, a federal trademark registration can protect your brand identity from being copied or replicated by competitors in a way that could confuse your clients and customers. This way, trademark registrations keep a spotlight on your business by ensuring that your brand remains truly unique and stands out from the crowd. So it's no wonder that people are flocking towards these trademark registrations. There are so many that get filed every year, and the number just keeps on going up. But like I said at the top of this video, there's no such thing as trademark rights without use in the US of A. And there are two types of use that are relevant here: common law use and use in commerce. Let's start with common law use. This is the easy one. Common law use of a trademark is established once you begin publicly promoting and selling your products and services. You don't need to make any filings or pay any fees to claim common law trademark rights. They simply poof into existence when you make your first sale of your product or when you first begin providing your services. The downside of common law trademark rights, however, is that it's going to be limited to the places where you have actual market penetration. That means the places where you have actually sold your products or provided your services. And that protection can be extremely limiting, right? So let's say, for example, that you set up your business in California and you've only made sales so far in Sacramento. So you have common law trademark rights in Sacramento. But that doesn't mean that you can stop somebody in Los Angeles from selling similar products and services under a similar trademark as yours. So if you do get into a dispute over common law trademark rights, there needs to be a thorough investigation done to see where those trademark rights actually extend and how far your protection actually reaches. And as part of that investigation, you might find out that your trademark rights are nowhere near as broad as you thought they were. And that's why people tend to prefer federal trademark registrations, because they provide protection for the entire country without having to get the nitty-gritty of whether you've made sales in each state, region, locality, municipality, whatever. You get nationwide protection without all that hassle. But to qualify for a federal trademark, you have to go beyond the common law use and establish use in commerce. This is the second type of use that I mentioned earlier. Use in commerce is a technical legal term with a complicated definition, but it just boils down to this: your use of your trademark in the sale of your products or the provision of your services must have some impact somehow beyond your home state. That in commerce portion of the phrase refers to commerce or economic activity that can be regulated by the federal Congress. Without getting too deep into the complications of federal constitutional law, the Commerce Clause of the Constitution gives the federal government the right to regulate activity that has some sort of impact on the national economy or a broader economy that encompasses more than one state. And so this hook is what is needed for the federal government, like the United States Patent and Trademark Office, to be able to make a decision about your legal rights involving your trademark and to issue you a trademark registration that covers the entire country. So along these lines, regarding use in commerce, there are two types of use that you might want to consider. The first one is the easy one, which is interstate use. Interstate use is when your use crosses state lines. In the case of products, that is if you sell or transport your products outside of your home state in some way. In the case of services, that will be if you provide your services outside of your home state. So if you sell products, you might establish use in commerce if you ship your products to customers outside of your home state, if your products are sold at a retailer outside of your home state, if you travel to sell your products, such as if you attend trade shows or do different pop-up shops in various locations outside of your home state, or if you establish a physical location outside of your home state where you sell your products. If you're a service provider, on the other hand, you might establish interstate use in commerce if you have clients that are outside of your home state. So an example of that could be if you design websites for your clients and they can book you from wherever, and within your home state you are designing websites for people from all over the country. Or if you are a makeup artist, for example, and people fly you out to different parts of the country to do their makeup for them. Turning now to the more complicated type of use in commerce, let's discuss intrastate use in commerce. Unlike interstate use in commerce, this use may not cross state lines. The activity itself occurs mainly within one state, but it still has some sort of impact outside of the home state of the trademark applicant, which is what gives the federal government that hook to be able to register the trademark federally. The easiest and most common way to establish intrastate use in commerce is to post a website where you sell your products and services. Because the website is accessible to anyone, anywhere, it can impact the economy outside of your home state. So in the case of products, when you make your first sale through your website, you establish intrastate use in commerce. And in the case of services, once you provide your first service to someone who has booked you through your website, you have established intrastate use in commerce. Another example of how you can establish intrastate use in commerce is if you have a store or some sort of physical location where people come from out of state. So you aren't necessarily going to them, they are coming to you. This is the case for many types of service businesses like hotels or restaurants, where the people who use their services travel from out of state to come to their location. So even if the hotel or restaurant only has one location in one state, they may still be able to establish use in commerce based on their intrastate use. But this kind of intrastate use can apply to people who sell products too. Let's say, for example, you have a souvenir shop in a tourist location and people from all over the place come to purchase your products to get reminders of their trip. Even if you don't have a website for your business, the purchases from those out-of-state customers can still help you to establish use in commerce on an intrastate basis. Just remember, regardless of the interstate or the intrastate nature of your use, you must actually be selling your products or providing your services. Advertising is not enough. Sidebar, there may be some situations where you can establish use in commerce for products without an actual sale, such as if you are distributing promotional items, or if you are importing your products from abroad, or if you are transporting your products to test customers in a way where your trademark is very clearly visible on the products themselves. These kinds of situations are the exception to the rule, and there are many different things that have to be considered to figure out whether use in commerce actually exists in these cases. The easiest way to establish use in commerce for a product is to make a sale that has some sort of impact outside of your home state's boundaries. And you don't need to charge for or sell your services to qualify for use in commerce, which is why nonprofits can and do qualify for trademark registrations. All right, with that out of the way, let's move on to what this use in commerce stuff means for an actual federal trademark application. Because when you apply for a federal trademark, you will need to provide to the USPTO two very important dates. The first date is your first use anywhere date. This will be the date that you established common law use for your trademark. The second date will be the first use in commerce date. That, of course, will be the date that you had your first sale if you are selling a product, or the first day that you provided your services in a way that had a reach outside of your state. So let's look at a few examples to get a better sense for how this actually works in the trademark application process. John registered a New Jersey LLC to sell t-shirts and caps under his trademark. He's only made 2 sales so far. One to a customer in Newark, New Jersey on January 12, 2023, and another one to a customer in Fort Lee, New Jersey on February 12, 2023. And his trademark is prominently displayed on the hang tags of his t-shirts and caps. So what use has John established? Well, when he made his first sale in January 2023, he established common law use. However, he has not established use in commerce yet because he sells products and he has not made an out-of-state sale. So if he were to apply for a federal trademark immediately after his second sale, he will be doing so on an intent to use basis, because that is the right track for someone like him who wants to get protection for his brand, but they haven't yet established the use in commerce required for a federal trademark. Another example, Jennifer is a masseuse who is licensed in New York, where her business is also registered. She's getting ready for her grand opening, which hasn't happened yet, but she set up a website with all the details about the grand opening and about what her future pricing will be so that people can get details about how to work with her. Her trademark is in big, bold font on the website, and people can easily see what the trademark is. What use has Jennifer established? Well, she really hasn't established use, right? All she's done so far is advertise her service. She has no clients yet and has not provided that service. However, if she wanted to apply for a federal trademark, she could, right? Just the way that John did, she would apply on an intent to use basis. Okay, those were hard. Let's do a couple easy ones. Kayla has a business registered in Missouri that sells books and planners and other types of bookie accessories. Her trademark is printed prominently on the back of her trademark so that people can easily recognize her business as the source of these products. Her first sale was to a customer in St. Louis, Missouri on July 3rd, 2024. And her 10th sale was to a customer in Tallahassee, Florida on August 17th, 2024. What use has she established? Well, she established common law use with her first sale in July, but she did not establish use in commerce until she made that out-of-state sale to the Florida customer in August. So if she were to apply for a federal trademark, she would qualify for the streamlined in-use basis, and she would report her first use anywhere date as the date of her first sale to her St. Louis, Missouri customer, and her first use in commerce date would be the date of her first sale to the customer in Tallahassee. All right, last example, quick one. Kadeem is a cybersecurity consultant with a business registered in Pennsylvania. His website prominently features his trademark, is available to anyone, anywhere, and features a booking link for people who want to sign up as clients. His first client is based in New Orleans, Louisiana, and he provided services to this client for the first time on March 3rd, 2021. What use has he established? Well, he has both common law use and use in commerce. When he provided services to his first client, who happened to be an out-of-state client, he established both at the same time. So he too could apply for a federal trademark on that streamlined in-use basis, and he would report his first use anywhere date and his first use in commerce date as being March 3rd, 2021, the date on which he served his first client, who just happened to be somebody who was out of state. Now, I hope that exercise wasn't too painful, but I think these examples are really good to help you understand the distinction between common law use and use in commerce, because you will need to understand this to file a federal trademark application. If you report the wrong dates to the USPTO, it's kind of hard for them to know that the dates are wrong, because they take what you say at face value. They do not do an independent investigation into the facts to determine what your first use dates were, because they don't need to. When you sign your trademark application, you are verifying that all the facts, including your reported use dates, are correct, and you agree to accept serious legal penalties, including cancellation of your trademark registration if anything is incorrect. And if you report wrong information about your use, whether you provide a date that is earlier than you actually began using the trademark, or if you provide a use date that doesn't exist because you never actually began using the trademark, that can be a reason for your trademark registration to be canceled. And mind you, it's not going to be the USPTO that brings up the cancellation issue. It will be a competitor, someone who thinks your trademark registration is in their way and who wants to get it out of their way. So they will not give you a break and they will not go easy on you. That's why you can't afford to be inaccurate in the dates that you report to the USPTO. So if you're unsure about whether you've established use or whether you have common law use or use in commerce, the best thing that you can do is reach out to a trademark attorney. That person can help you do the research and analysis to lock down the most accurate information. And that's all from me. Now you have a better understanding of common law use and use in commerce. At least I hope that you do. If you found this video helpful, please give it a thumbs up and don't forget to subscribe for more content and to turn on the notification bell so that you get notified when I post a new video. If you have thoughts or questions to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.